So on page 71, one of the first parts that comes up, which was hilarious, it goes into the history of how the DS came about. So the DS system came up in 1978 for F visas, 1985 for J visas, and the goal was to make it easier for people to be able to like just come and go and not have to do extension of status. Because imagine it's a hassle to have to do an I-539 extension of status, filing fees, more government delays to be able to keep going to school here, especially as people go to college here, probably go to grad school too, or they do OPT afterwards and all this kind of stuff. So having to file extension of status becomes a big hassle. And they say they cite that in 2023 alone, there were 1.6 million admissions in F status, a dramatic rise from when legacy INS naturalization first shifted in 1971. So this is misleading because in 1980 there wasn't as much air travel. This 1.6 million number, most likely, it's from this what is it, footnotes right here. I looked up this naturalization yearbook, the legal immigration adjustment status report, and I couldn't get a breakdown of what this number was, but most likely, I'm 9 out of 10 sure, that 1.6 is the number of admissions in F status. So if you have a Mexican student who came to San Diego to study and then on the weekends goes back home, each admission is just one person doing the same trip. So when you say 1.6 million admissions, that could be a smaller number. It would be a smaller number. People who travel for summer, for winter, they might go on vacation to Canada. So that's a very misleading number to put up there. And so that was just a joke that they were going to cite those kind of numbers, and it shows a misleading thing they do. They said in 2023, there were over 500 admissions in J status and over 250%, up from over 250% for J's since 1985. And it's not really a comparison with today's travel and internationalism that exists from that time. And they're saying this poses a challenge to the Department of State's ability to monitor and oversee these non-immigrants while they're in the United States, which is not really true. And this is going to be a continuous theme, is they're searching for a solution here for a problem that has already been solved. And the problem is called SEVIS, SEVIS. Schools list if a student's not maintaining status, drops under, gets bad grades, they get reported into ICE's system. Now, I'll give it to them that they didn't have enough ICE officers, and this has been abundantly clear, reported on many times by the government for a decade plus, that they don't have enough ICE officers relative to the number of students, because the student numbers have grown. That's factual. And so they just don't do anything. So they get reports of all the problems that are happening, that not all of the problems that do happen with the students, but they don't do anything about it. But they've already solved that solution with the big, beautiful bill and hired all these ICE officers. All they got to do is get the CEVIS report, send a letter to students, and send an NTA if it's a case, if it's a problem. They don't have to create this whole bureaucratic system, which we'll see is going to cost hundreds of millions of dollars, when they can solve it with the existing systems that they have just by sending letters to people to do an NTA. And that takes them out of a duration of status, because they got to notice, I think it has to be a finding. So maybe by a judge or just some USCIS notice that says out of status or RFE on it. So there's much simpler ways to deal with this. It doesn't need to create this extra bureaucracy that goes with it. Another thing that they say here, again, goes to like how ridiculous this is. They cite that in footnote 16, DHS has identified 2,100 aliens who first entered the F1 students between 2000 and 2010 and remain active status as of 2025. So the biggest problem they have that they're trying to solve is 2,100 people that have been staying the F1 student status. They've identified these people. They know who they are. If you charge $10,000 a person in employee fees to go and handle this, which is going to be much less than that, but that's going to be only like, I can't even do the math, but it's like $2 million, $20 million, something like that. Not the 300,000 to 400,000 they're quoting to solve this problem, that they're the new solution that they're putting. So it shows again that that's a taxpayer issue. They're going to spend a lot of money and cause a lot of havoc in upper education for creating this. And so they go into here for F and J visa holders. The Immigration Nationality Act specifically states that aliens must have a residence in a foreign country which they have no intention of abandoning to enter U.S. Yet DHS has many examples of students and exchange visitors staying here for decades. That's where the reference is 2100 there. This has always been a problem if you're doing an extension of status in the U.S. or change of status to a B2 or F1 or all this kind of stuff about the home residence requirement. It's very hard to do that. If you've been staying here 4 years of college, you're not going to keep a home back home. But that's how it's been.